Welcome to our presentation on Seminar 6, Question 2. Before we start, here is a brief summary of all the key facts. Siblings Adriana and Giovanni are sole directors of gelato chain Kono Limited, which opened in April 2018. In May 2021, the company reached its overdraft limit of $250,000 with creditors MyBank Limited. In return for increasing the overdraft to $300,000, MyBank demanded security over all the company's equipment and flagship store. In August 2021, Kono Pty Limited received a statutory demand from Chocolate House Limited for outstanding invoices dating back to March 2021. With this information, the key legal issues we will look into are 1. Whether the company was solvent. 2. If yes, are the directors liable for insolvent trading? 3. What are the defences the directors can use if the company was in fact trading whilst insolvent? And 4. What penalties and remedies would the company and directors face? Here are some relevant laws to answering the question. Section 95A of the Corps Act, which deals with determining solvency status. Section 459C subsection 2A, which states that if a company fails to comply or contest a statutory demand within 21 days, it is deemed to be insolvent by the court. Section 5A8G, which relates to the duty of directors in preventing insolvent trading, and 5A8G2, which deals with directors who fail to prevent the company from incurring debt. Section 5A8GA, a provision introduces a safe harbour which states that directors that do certain things to potentially benefit the company could be absolved of liability under 5A8G2. However, the evidential burden lies on the directors. Section 5A8H are statutory defences that can be used in an instance of insolvent trading. Section 5A8J, K and L, which are related to the civil penalty order. The court may order compensation or criminal penalties, which will be enforced by Section 5AAL. And Section 5AAM, which provides that directors can be personally liable should they be in the wound-up process and fail to pay unsecured debts. We will also be referring to the cases of Statewide Tobacco Services v. Morley 1990, ASIC v. Plyman 2003, and Deputy Commissioner of Taxation v. Clark 2003, which will be explored later on. The first legal issue is solvency status. Kono Limited is in debt to Chocolate House Limited, relating to unpaid invoices dating back to 5 months earlier. Based on this information and interpretation of Section 95A of the Corporations Act, we would assume Kono Pty Limited is taken as insolvent as the company is not able to pay all debts as and when they become due and payable. The company has also received a statutory demand from Chocolate House. The company has 21 days to comply or contest the demand, otherwise the court must presume that Kono Pty Limited is insolvent under Section 459C subsection 2A.
Section 588G1 applies to Adriana and Giovanni as subsection A, B, C, and D are satisfied. In accordance with Section 588G2, by failing to prevent the company from incurring the debt, the person contravenes this section if A, the person is aware at that time that there are such grounds for so suspecting, or B, a reasonable person in a like position in a company in the company's circumstances would be so aware. It is evident that the company was experiencing financial difficulties due to external influences, with the company's overdraft reaching its limit at $250,000 and the existence of unpaid invoices dating back to March. By increasing their bank overdraft limit to $300,000 and subsequently laying down all their equipment and their flagship store as security when there is no certainty of future benefits to flow from this transaction, it is likely that Adriana and Giovanni are in breach of their duty to prevent insolvent trading by the company furthering their debt and ability to repay any possible trade creditors. Applying the outcome of Statewide Tobacco Services v. Morley 1990, it is essential that Adriana and Giovanni are aware of the financial position of the company and have adequately informed themselves in relation to the company's affairs. Directors that do not participate in monitoring the financial performance of the company or attempting to hide behind ignorance will not be able to claim a defense against insolvent trading.
The third legal issue is defences. Section 5AAH provides some defences for directors against 5AAG2. However, Adriana and Giovanni do not satisfy these grounds, as at the key time there was no reasonable expectation that the company was solvent. They had already displayed an inability to repay debts on time in the outstanding invoices from Chocolate House, dating back to March 2021. The facts did not reveal any additional information in relation to subsection 4 about illness or any other reasonable grounds, nor did it mention the appointment of an administrator or restructuring practitioner. Hence, it appears that they would be held liable for a breach of directors' duties under Section 5AAG. This is similar to the ASIC vs. Plyman case, where the court found that neither Elliott nor Plyman had taken any steps to prevent the company's insolvent trading. This case is also significant in that it requires all individual directors to take reasonable actions to prevent insolvent trading. However, Section 5AAGA provides safe harbour, rendering Section 5AAG2 inapplicable in circumstances where directors start developing one or more courses of action that are reasonably likely to lead to a better outcome for the company. If Adriana and Giovanni were to utilise this safe harbour, they would face the evidential burden to prove they fulfilled one of the 5 possible defences within subsection 5AAGA. The only defence they could realistically attempt to prove is subsection 2A, which requires that they properly inform themselves on the company's financial position, as subsections B through to E are unlikely usable in their situation. Within Adriana and Giovanni's situation, it is stated that they held hope for improving their financial prospects, meaning that they likely had somewhat informed themselves of their company's financial standpoint. If they fail to meet the evidential burden to prove this, they could face civil penalties under 5AAG and further action under 5AAM, JK, and L. Adriana and Giovanni do appear to be in breach of Section 5AAG directors' duties to prevent insolvent trading by the company. However, there is a possibility that 5AAG won't apply under Section 5AAGA, the safe harbour.
Under Section 588G subsection 2 note, a breach of the director's duty to prevent insolvent trading by a company is a corporate scheme civil penalty provision listed under Section 1317E. Furthermore, under Section 588G subsection 3D, directors may also be liable for a criminal penalty if the person's failure to prevent the company incurring the debt was dishonest. Nevertheless, there is no evidence that they engaged in dishonest conduct. Thus, Section 588K compensation order by the criminal court may not apply. Alternatively, from their effort to trade their way out of the situation through promotions and classes, we can assume that their failure was not dishonest in nature, but rather a consequence of external influences out of their control. Hence, they may only be liable for a breach of civil penalty provision, meaning the court must make a declaration of contravention. This will allow ASIC to apply for a pecuniary penalty order or a disqualification order under Section 206C. In addition, the court may order the company to pay compensation equal to the amount of loss or damage incurred to the unsecured creditor under Section 588J. Section 588L supports the enforcement of such an order. In the case that they did succeed in proving safe harbour, an important section to note is 588M, which gives the liquidator statutory action for compensation from a director who has breached their duties under Section 588G. This can occur even when a civil penalty order has not been made. Hence, even if Adriana and Giovanni were to claim safe harbour, they could still be personally liable to pay recovery amounts to possible creditors. In this case, it is important to establish both Adriana and Giovanni's roles as a director. The facts imply that Adriana is head of operations and hence Giovanni, as master gelato maker, may not be involved in the management of the company. Applying the outcome of the DPT versus Clark case, he will face the same liability as Adriana, given that he is a director even if he did not instigate the insolvent trading of the business. Adriana and Giovanni are likely in breach of Section 588G to prevent insolvent trading, and thus they could both be held liable. It appears they will be unable to use the defences under Section 588H and may face a civil penalty under Section 588G. However, under Section 588GA Safe Harbour, Section 588G may be inapplicable and they will not be liable for a civil penalty. Additionally, Section 588M provides that the directors can be held personally liable regardless of whether they committed a civil penalty or not. Hence, it is highly likely that they will be required to pay compensation.